Guardianship of Minors. This is part of an informational video series produced by CHS. This video is intended for informational and learning purposes only and shall not be construed as legal advice. CHS is not liable for any misuse of information. Guardianship has many different subtopics. This video will focus on minors, meaning children under the age of 18, and what prospective guardians need to know. What is a guardian? A guardian is appointed by the court and is legally responsible for the child until the child is either discharged by the court or the child turns 18. Who can become a guardian? A guardian must be at least 18 years of age or older, of sound mind, a resident of the United States, not adjudicated person with a disability, not convicted of a prior felony. However, the court may appoint the person convicted of a felony in special circumstances. Who needs a guardian? A child under the age of 18 and whose parents have either died, the parents agree to guardianship, parents whose whereabouts are unknown, or parents who cannot or will not care for the child. If a parent does not agree to guardianship, a child must have been living with a possible guardian for a significant amount of time. For example, grandma has raised the child, grandma can become the guardian. The child cannot be the subject of a DCFS, juvenile case, divorce, or parent custody case. The guardian's rights and responsibilities as follows. Make day-to-day decisions for the child. Take custody of the child. Enroll the child in school and make sure they attend. Shelter, clothe, and feed the child. Pay the child's expenses. Obey court orders relating to the child. Keep the child safe. Consent to the child's medical treatment. Apply for and receive possible public benefits for the child. For example, food stamps or medical insurance. It is important to note that public benefits for the child are not guaranteed, and a child's immigration status will not change with guardianship. Some possibilities when the guardianship will end. The guardianship is always subject to court order. Parents have the right to ask the court to get the child back. Guardians must ask the court to return the child to the parent or to change guardians. The court will end the guardianship only if it's in the best interest of the child. Parents usually have a right to visit the child. What to do if guardians plan to travel or move a child. Parents have the right to know where their child resides. Guardians must inform the court and the parents when there's a change of address. Guardians must tell the parents when the child is away from home for more than a few days. Guardians must ask the court to take the child out of state for more than 30 days, and they must prove that this is in the best interest of the child. Guardians must ask the court to move out of state with the child and prove that moving is in the best interest of the child. How can the court help? The Circuit Court of Cook County Guardianship Assistance Desk can help prepare forms to file for guardianship of a minor. When you come for your appointment, bring a valid state ID, the child's birth certificate, either a notarized consent from the parents or their last known address, a death certificate. If you do not meet low income rules, bring money for filing and court fees. If you prefer to do the guardianship yourself, you can call the court and ask for a do-it-yourself guardianship instruction packet. Some important things to consider before you proceed. Guardianship is a legal matter. You must comply with the law. You will have to appear in court. It takes time and may require payment of court costs. Statements and information given to and in court are made under oath and subject to perjury if found false. Perjury is a Class 3 felony and is punishable by 5 to 9 years in the penitentiary. Remember, CHS, the Community Outreach and Advocacy Program, can help you. Contact us anytime through email, video phone, or text. The information is on the screen.